As you have heard, my name is Matt Murphy. I'm going to give you just a little bit more background, not because I do like to talk about myself, which sometimes I've been accused of, but to also give you a little bit more perspective of where I'm coming from. When I first started my legal career, thank you. Does that go forward?
Forward, back.
Great. When I graduated from law school, my first job as a lawyer actually was as a claimant's attorney. I spent 10 years doing exclusively claimant's work. It was probably about 60% tort PI cases and about 40% workers' compensation claimants. But I was, probably based on the crowd that I'm talking to today, the enemy. After about 10 years of doing that, I got, maybe a change of heart, I wasn't excited about what I was doing anymore. I decided maybe I'm going to give public sector work a try. Contacted some friends that I had in Jeff City, and lo and behold, next thing I know, I was general counsel for the Missouri Department of Labor. And as Randall explained to you, the Missouri Department of Labor is one of the departments. Within the department are 3 divisions and 2 additional entities. The Division of Labor Standards, which does minimum wage and prevailing wage work. There is the Division of Employment Security, which is UI or unemployment, Division of Workers' Compensation, and then also the Board of Mediation and the Missouri Commission on Human Rights. Did that for the last part of Governor Blunt's term, and then as he was finishing up his term, I was appointed as an administrative law judge down in southeast Missouri. And I suspect most of you all are from the southwest Missouri area. Most of your claims involve southwest Missouri, Springfield, Joplin, and so on. So you may not realize the significance of when I say I was a judge down in southeast Missouri. If you talk to folks who have a good idea of how the entire state works and the various offices within the Division of Workers' Compensation, I think the prevailing wisdom is they're just plain crazy down there. And I didn't realize that. When I went down there, I hadn't done a lot of practice down there. My wife's family is from West Tennessee, so it seemed like a good fit that'd be an all right place to relocate to. Southeast Missouri and the Cape office is extremely claimant-friendly. They have some practices and procedures that are very odd and inconsistent with the rest of the state. And I came down there, and I was kind of a stranger in a strange land for quite some time. After about 3 years of that, I went back into private practice and relocated back up into Columbia, where I'd been for 20-something years, and began a defense practice. So why did I switch? Frankly, I enjoy dealing with the employers more than I did the claimants, I think, if I'm being totally honest. There's a lot of calls. Why isn't my case settled? Well, because it takes time. Well, I need money. Well, I get that. But that doesn't change the fact that these things take time. I received a lot of that stuff, and that might have been what drove me out of claimants' work in the first place. So for the last 2.5 years now, I've been doing almost exclusively defense work. When I say almost exclusively, I mean except for traffic tickets for family members, I think. They're the Leadfoot Murphys, you know. So what we're going to do today is we're going to talk about workers' compensation. I'm going to paint with broad strokes. I'm going to sometimes dive down into what I think is the real nitty-gritty and what's some interesting practice points for you all and what you all should really be keeping in mind as you are trying to navigate the system and do right by your employer. We're also going to touch on unemployment. As Randall said, there really hasn't been much going on in unemployment. There's been some cases in the last couple of years that we'll talk about. But really, workers' compensation is where it's at as far as moving and shaking. There's been some interesting cases in the last year and a half that have had some pretty far-reaching implications. Unemployment, not as much. Since you've got me all day, I can bump the second speaker, which is me, and we're going to probably go past the break with workers' comp and do a little bit of UI. As Randall also said, I invite you to stop me at any time, ask me questions. I want to talk about what you all care about, what you want to know about. It doesn't make any sense for me to talk about what I like to talk about. You're not going to derail me. I'll get back on track just fine, so don't worry about it. Please do let me know. If you do ask a question, I've been told to parrot the question back at you. so that the recording. So that's why it's not an idiosyncrasy. All right, so let's start with workers' compensation. Again, some of this stuff may seem very rudimentary and basic, but it's the way I do things, kind of set the stage, and then we'll get a little bit more down into the nitty-gritty. And I'm sorry if I'm blocking for some of you, but the camera. Primary legal issues that we're going to talk about are compensability, medical care, and of course, permanent disability. Now, I did not add TTD or TPD, comp wages, to the mix today. One, for time reasons, but two, it's not a lot going on, certainly from a legislative or case standpoint. It's usually fairly simple to determine what are the wages that are owed. I say that, I got a call as I'm driving down yesterday from a client of mine. I represent a lot of auto dealers. The carrier wanted to know, hey, I've got a TTD situation, what do we do with this? The employee was allowed to go back to work 1 day a week. He's an auto salesman. The way auto salesmen work is if they work the week, they can get some number of hundreds of dollars draw that counts against any commissions that they earned during that time period. Since he was only there for 1 day, they didn't give him any draws. He comes back the following week, gets $22,000 worth of commission for signing some sales on a big sale. Well, what does that mean? Do they get credits for that for the past week? Does it count for the pay period? It was really an interesting question and very difficult. So while I say that generally TTD is not that complicated, of course, like all things, if you ask a lawyer, it can become complicated. So let's talk about compensability. Of course, the first thing that we talk about with compensability is, was there an accident? Obviously, if somebody just simply is sitting at their desk, has a heart attack, generally speaking, that's not going to be considered workers' compensation, right? There's got to be some sort of accident. Putting OD or occupational disease aside for a moment, something has to have happened. And an accident is defined in the statutes as an unexpected traumatic event or unusual strain identifiable by time and place, okay? Essentially, something happens. Let me also add one caveat while I'm thinking about it. We had those severe storms coming through Columbia a couple of days ago when I was putting the final touches on my PowerPoint. As I was saving it, we got hit by a flash at that very moment, so while my computer was actually in the process of saving the file, that's when it blinked out and it corrupted the file. I called Randall yesterday. I said, hey, we got a problem. I don't have the PowerPoint ready like I was supposed to because it got corrupted while I was saving it. He said, well, we need PowerPoint. I said, I know. So what are we going to do? I met with a client yesterday morning in Kansas City. Once I was done with the client, I sat in a Starbucks for 90 minutes and recreated this from memory. So it was banged out very quickly. I did not proofread it. Please forgive any typographical errors. The substance is sound, I believe, but there may be weird things. I did notice that Matthew Murphy is going to be speaking next. I don't know who he is, but I'm looking forward to meeting him. So an accident, unusual strain. We kind of know what an accident is, and we're going to talk a little bit more about it, but there has to be some event, okay? And as long as there's some event that causes some strain or trauma, then you've probably got an accident. This is not rocket science. I think we probably, most cases, know when there's an accident. This is when it gets a little bit more tricky, okay? Because just because there is an accident doesn't necessarily mean that we have an injury. And you've got to have both in order for there to be a compensable injury, all right? You can have a car accident, of course, and not be injured in it, okay? A low-impact injury or low-impact collision would be a very good example of accident with no injury. And even if there is some resulting pain from the situation that results from the accident, that isn't necessarily an injury, because as we probably all know by now, and we've heard ad nauseum, prevailing factor, prevailing factor, prevailing factor. Well, this is where that prevailing factor, that term that we hear so much, comes into play, because the accident has to be the prevailing factor in causing both the medical condition and the disability, all right? If there are other factors in play that contribute to the medical condition or the disability, well, then the accident might not be the prevailing factor. And so what does prevailing factor mean? It is the primary factor when considered against any of the other factors, in relation to any other factor. That doesn't mean that it has to be 51%. If there are 4 factors, I guess the prevailing factor would be if the accident was 26%, because then it would be the largest of the others, if they were spread out evenly. I know I'm getting a little bit mathematical here. My undergraduate degree is in engineering, so I will do that sometimes. But suffice it to say, if there's several factors, age, deteriorating condition, and this accident, as long as that accident is to a greater degree caused the medical condition and the disability as compared to those other factors, then you've got prevailing factor. This was a big deal, obviously, in 2005, and this was meant to kind of trim back those things that were being paid on through workers' compensation. And for the most part, it's done a fair job of that. Not surprisingly, every doctor that is now asked the question by the claimant's attorney as to whether or not the accident was a prevailing factor in causing the injury, the answer is always yes. It's not because there's been a change in medical science. It's not because they went to the latest CME and found out about this new thing, prevailing factor. It's because the lawyer told them, hey, the law's changed, okay? I need you to say prevailing factor. So that's, so has it had all the improvement and help that was hoped? Maybe not, but it certainly has improved things. And this is a great example. This was one of the first cases that came out that discussed prevailing factor, and this was City of Gordon v. City of Ellisville. Basically what happened was somebody had an accident, all right? There was a traumatic event, hurt their shoulder. It was suspected that there was a rotator cuff tear. Surgeon, the employer's doctor even said, I think there's a rotator cuff tear. Treatment was authorized. Went in, scoped it. Lo and behold, there was no tear. Turns out the MRI had a shadow that wasn't what they thought it was. So when they went in, the doctor closed up, wrote his report, said turns out there was no tear. There was just simply aggravation of his pre-existing injury. Not comp. And it went to the Court of Appeals. The ALJ, I believe, said that it was not comp. The commission said it was not comp. And certainly the Court of Appeals, the only opinion that really matters, said it was not comp. Found that there was no acute injury, and the accident was not the prevailing factor in causing his problems. All right, it was degeneration. So this is a prime example of where the prevailing factor standard comes in and helps you, because under the old substantial factor, I wasn't hurting before, this happened, now I do hurt, that was enough. All right. Under substantial factor, prevailing factor, you've got to have some sort of insult and to the body, and there has to be related to the accident. This by itself, while it's interesting, comes into play here down the road when we talk about some other things. So then the big one. Now we're going to figure out, we're going to get the Supreme Court to weigh in, the Missouri Supreme Court to weigh in on this. This was a case that has been cited quite a bit now because it's the first one. Frankly, it was a terrible case for the plaintiff's bar to take to the Supreme Court. I was actually talking with the attorney who represented the claimant 2 weeks ago on a claim that we have that he has against one of my clients. And we were talking about this case, and he said that, as a matter of fact, MATA really encouraged him not to take this case to the Supreme Court because the result was obvious, and it was going to be bad law for the claimant's bar. I guess his response to them was, "Well, I don't represent MATA. I represent this client, so I'm appealing it to his credit." So he took it up. He lost, as would be expected. Miller versus Missouri Highway Transportation Commission. This was a MoDOT worker who was walking briskly down the side of the road, and I put that in quotes because that's actually stated in the opinion, and it's actually discussed. For whatever reason, it was important. But he was walking briskly. It was determined that he didn't have to walk briskly. He just chose to walk briskly. He did not step in a pothole. He did not trip over an irregularity in the road. Just walking, and all of a sudden, bam, his knee explodes. Okay, he tried to get taken care of under workers' compensation. He was denied workers' compensation, went all the way up to the Supreme Court, and the Supreme Court agreed and said that while the injury arose during the course of employment, it happened at work, it did not arise out of the employment. Just like a bunch of lawyers to come up with some gem like that. But that just means that just because it happens during work hours doesn't mean it's comp. And I don't know what your all's position is on these things, but I've had a number of folks come to me and say, well, I thought if it happened on the clock, it's comp. And please don't think that. There's a lot of times that it is not comp related, and we're going to get into some of these situations. But it is important. The obvious one, when they drop the cinder block on their toe and break their toe, it's comp. But as we go down the road here and kind of learn about some of these other things, start taking a hard look at these things. And if you work with your counsel or your insurance company really well, call them on the front end, because that can be very helpful on and we'll talk about why down the road, getting maybe a quick opinion on some of these things. In any event, Missouri Supreme Court said it's not workers' compensation. So this one got waved around quite a bit by the defense bar. This is another really good case for the defense bar. I'm buttering you up because the rest of the talk is going to be terrible. All the other cases, I'm hitting you with the good ones early. This one is called Jomey v. St. John's Mercy. Any healthcare employers here, hospitals, doctors? God bless you, because you guys fight everything. We get more cases that are St. John's, St. Mary's, St. So-and-so's. The saints are in the courts all the time. It's something else. And so a lot of these cases come from these healthcare providers. As a matter of fact, Pyle, that Jomey refers to, is one down in South Missouri that was St. somebody. So St. John's, or Jomey versus St. John's. What happened was a woman was making coffee. And at some point during the coffee-making process, or when she was done with the coffee-making process, she turned to walk away from the coffee maker. She was wearing, I believe, a wedge sandal, gentlemen. It was a triangle she was standing on. As she turned, her foot fell off the triangle. Okay, it caused an injury to her ankle, and so she filed a workers' compensation claim. Now, what had happened some number of months prior to this happening, there was a case down in southern Missouri. It was called this Pyle versus St. somebody case. And what this Pyle case did was the Southern District Court of Appeals said there's a two-pronged test in Missouri. First, we decide if the injury occurred while somebody was performing an essential function of the job. And if it did, the analysis stops and it's comp. Now, that decision, in my opinion, was so ridiculous when I first read it the morning it came out. I was an ALJ down in Cape at that point. I grabbed one of the other ALJs, and he is one of the most claimant-friendly ALJs you'll ever meet. And I said to him, read this thing. This thing is garbage. I can't believe they came up with this. What do you think? And he agreed it was garbage. He was shocked at this, quote, two-prong test. So this happens in St. Louis area, in the Eastern District, and the Court of Appeals said, well, if we're going to follow Pyle, she was performing an essential function in the job because she was told to make coffee. So that would be comp, but we just don't buy into Pyle. So we think the Supreme Court should take a look at this. And they did. So what the Supreme Court said is that it's not compensable. And basically, this was an equal exposure case. And in case you didn't know, the statutes require that the injury occur due to some risk or hazard that the employee is not equally exposed to outside of the employee's employment life. And so what the court said was, well, let's look at the danger that the employee was subjected to. Well, in this case, the danger was making coffee or wearing the wedge sandal, or the combination of the two. And this was not a shoe that was provided by the employer. This was the employee's personal shoe. She testified that she's worn it in the past and wears it as that one comes up in the rotation, or however you all decide those things. And so it was something that she's exposed to routinely and away from work. And so the court said, well, if that's the danger, she's equally exposed to that outside of employment life, therefore this is not comp. This is, hands down, the best case that you all have ever heard or seen of, okay? We have used this personally time and time again. Where this comes up most frequently these days is staircases. It's amazing how often people fall downstairs or upstairs when they miss the step. And we have successfully defended some cases where an employee was merely walking up or down stairs, because I think we would all agree stairs are a fairly common encounter in our daily life, and therefore the danger of walking up or down stairs is not, or is something that you're equally exposed to. Now, so there's a caveat, okay? In each of these things, you have to look at, it's very fact-based and very specific to the case, all right? A case that we just had a trial on, one of my partners defended a sheriff's department. We represent Missouri Association of Counties, and so this deputy was walking down the steps. He testified that he heard there was a call coming in, so he did this to listen to his radio, and because of this, he fell down the steps. I don't think that was unique. I don't think that's something that they wouldn't have been equally exposed to. We all kind of look around, I'm sure, when we're on the steps. But fortunately, there was some evidence, some questionable evidence as to whether he even actually received a call at the time he was going down the steps. The judge didn't believe that he received a call, so she just felt that he was walking down the steps, and she denied compensation. And that case is going up to the commission, and so we'll maybe see how the commission weighs in on it, but I think the commission will be consistent with the ALJ. Then there was a case in eastern Missouri, Harley-Davidson dealership. Guy was walking up or down steps. They were moving Harleys to the back, walking up or down steps, and he testified that he was carrying his motorcycle helmet. Now, as most Harley salespersons do, they ride Harleys in their spare time. Folks like me who don't have a motorcycle don't sell Harleys. So he testified that, I had my helmet, but it didn't have anything to do with it. I just fell down the steps. The Court of Appeals didn't believe him and said, we believe the helmet did have something to do with you falling down the steps, and so we're going to find benefits. So I'm not sure what's going on in that situation. I'm not sure why the Court of Appeals really wanted to find compensation. I wasn't representing that employer at the time. Now I do. So I don't know if there was... I know the attorney. She's a very good attorney. But I don't know if she dropped the ball somewhere. I just don't know why. Why there's some facts in there that somebody was aggravated, that the Court of Appeals doesn't generally disregard somebody so that they can then give them benefits. If they don't believe somebody, it's usually bad for you. In this case, they didn't believe the person, and so it was good for them. So you got to look at each of these cases, and really consider what specifically is going on and what is unique about the situation. I got a call. Employee was looking behind a vending machine. He's a vending machine, works for a vending machine company, and was stocking the vending machine, and we're looking to see if it was plugged in or something along those lines. Is that compensable? I don't know. Was he just looking behind the machine and that's all he was doing? He hurt his back? If so, probably not. That's not a big deal. Was he getting down on his hand and bring his eye down to the ground to look underneath the machine? That might be compensable. That's not a maneuver that maybe you commonly perform throughout the day. So you kind of have to look at each of these things on a case-by-case basis and try and decide, what is the danger, and is the employee equally exposed to that danger outside of the employment. This is the walking down with his helmet case I was just telling you about. In spite of the fact that he testified that he carries his helmet all the time, the Court of Appeals didn't believe that and believed that the helmet was unique to the employment, and therefore compensation was awarded. So, while I've got a different slide, I've kind of been injecting this throughout. The practical application is when you get these cases, don't think about whether or not he or she was on the clock. Don't think about whether or not they were just injured. Okay, take a look at what was the activity that they were engaged in. It doesn't matter whether it was an essential function of the job or not. And take a look at the activity that they were participating in. And then, based on that activity, is that something someone does all the time? Walk down the steps? probably, maybe not compensable. Making coffee and just wearing a shoe, maybe not compensable. All right, a crane falls on them, probably compensable. Okay, that's not something we're exposed to a lot out of work. And you may not be able to decide. It may just come down to the evidence. I mean, that's certainly something I do a lot, and lawyers do a lot, as we try and, come on, don't you operate cranes all the time when you're not working? That one doesn't work. Any questions about that? It's kind of a good natural breaking point there. Yes, ma'am. Mm-hmm. Right. Repetitive trauma cases are a completely separate ball of wax. Okay, those are handled under a separate statute, 063 and 067. And more often than not, those are going to be competitive given the type of situation. I mean, the most common one you see, of course, is, and by the way, for the videotape, the question was, we see occupational or repetitive motion cases all the time, no accident. The woman who has been a secretary, typist, whatever, for the last 30 years is complaining that her hands are going numb. I don't care what in the world she does outside of employment. She's going to, just as a practical matter, she's going to be awarded compensation. That's just how those things work. There have been I've seen in recent years that there's been some studies and some data that shows that things like obesity, hypertension, smoking, age are just as big a factor in resulting in carpal tunnel as one's activity. And while that may be the case, judges aren't buying it. Okay, so when you have somebody that's been a typist for that many years or is working on the line and tightens that screw 75 times a day for the last 20 years, they're going to get the trigger thumb. And you're right, there's not an accident, but those OD or repetitive motion cases don't require an accident. They're treated separately. And those are some of the most difficult cases, especially when you get into issues like what's the statute of limitations, what's the notice requirement, because there is no easily definable time when you've got a triggering mechanism, because by definition it's happening over time. Your frustration with OD is shared by everybody, even the plaintiffs or claimants, because they oftentimes don't really truly have a good handle on when it's compensable and when it's not. Anybody else? Okay. So let's talk about medical care. Now it's a little bit of bad news time. As I'm sure each and every one of you knows, the employer is required to provide that medical care that is maybe reasonably be required after the injury to cure and relieve the employee from the effects of the injury. All right, straight out of the statutes. So, St. Joseph this time. A nurse was working. While she was working, she suffered an injury to her knee. There's no disputing that she was entitled to workers' compensation. There's no disputing that she suffered an accident, and there's no disputing that she suffered a meniscal tear as a result of the accident. The dispute lies with what were they going to do to solve her problems. As I recall, she was somewhat overweight. She had really degenerative, a very progressive degenerative condition of her knees. Both the doctors, the doctor for the claimant and the doctor for the employer, both agreed that the only way to solve her problem is to have a total knee replacement. A meniscus repair was not going to solve all of her problems because she still had this degenerated knee. And both of them agreed that, frankly, it'd be a waste of time to do the meniscus repair because it wouldn't be of any real value. Of course, where they disagreed was the employee's doctor said that the prevailing factor necessitating the knee replacement is the accident, and the employer's doctor said, no, the prevailing factor requiring the knee replacement is her pre-existing degenerative condition. So the Court of Appeals got a hold of it and said, you're both wrong. It doesn't matter what the prevailing factor was, because that's not the test for medical care. The test for medical care is what I showed you earlier. What is reasonable, what is reasonably required after the injury to cure and relieve from the effects of the injury. So the test for medical care is what is reasonable and necessary to relieve the patient. So what the Court of Appeals said was, employer, you have to pay for a new knee and replace the entire knee. There was a cheer heard throughout the land when this case came out from the claimant's bar, because the practical effect of this case is Tillotson gets waved around all the time. You better settle, or else we're going to make you pay for medical care for every problem this person has ever had up to the date of this injury, because we're going to win on Tillotson. Now, that doesn't always work, because it doesn't apply as often as the claimant's attorneys would like to have us believe, but it is a real concern, because once you replace the knee, you're also on the hook for the PPD that comes along with that replaced knee, not just the PPD that you would have paid for on going in and suturing up or repairing the meniscus tear. So it's a bad deal. Now, I can't say that it doesn't shock me. I think it's a problem with the statutes. I think a fair, unbiased reading of the statutes is probably gets you to this result. And I'll tell you, I had a case when I was down in Cape. A gentleman was in a bad car accident. Among other injuries, it really messed up one side of his jaw. In order to fix that side of the jaw, the dental opinions were that they were going to have to first fix the other side as well, to have whatever fix they were going to do over here anchored somewhere. You can tell I have a solid memory of this case, and with all these dazzling medical terms, I know. In any event, the doctor was saying, look, while this accident didn't hurt the other side, you're still going to have to fix that other side, because if you don't, this fix won't happen. And that was ordered under a temporary award. The employer did not provide that care. The employer's attorney did not a great job at the trial when it came to me. The employer's attorney didn't bring an opinion with, can't remember who the attorney was, him or her, saying how much the cost of a repair would be, so they only had the claimant's attorney's opinion. The claimant's attorney's opinion was it's going to be $45,000 to fix this mouth. If you don't already know, if you don't follow what the temporary award tells you to do, those are doubled. So they got hit for $90,000. I'm sorry, I hit them for $90,000 for some busted up teeth. I'm sorry about that. I feel bad about it, but that was where the evidence led me. But that was Tillotson, okay? And that was Tillotson before Tillotson was cool. So it doesn't shock the conscience when I read this, but now that it's out there, it's kind of enlightened a lot of folks, and it becomes a real factor when it comes to settling these cases, because oftentimes the claimant's attorneys are trying to tell you that, hey, you're going to pay for a lot of stuff. Now, there are some bright spots, okay? Armstrong, how am I doing on time, by the way? Okay. Armstrong v. Tetrapack. This was a case out of southeast Missouri, and the issue was a person had a knee or an elbow or a shoulder, one of those. There was some question about whether or not it was an aggravation of a pre-existing injury or whether it was a new injury. Very similar to the Gordon v. City of Ellisville that we talked about earlier, where they thought it was a shoulder. It turns out there was nothing there when they saw it. The judge found that there was not a compensable case because there wasn't an injury, and there wasn't the prevailing factor resulting in the disability. Well, in spite of that, the claimant's attorney kept saying, yeah, but Tillotson, you got to pay for that medical care that's reasonable and necessary to cure my client. And the judge said no. It went up to the commission, went up to the Court of Appeals, and the Court of Appeals agreed and said, look, Tillotson and your obligation to provide medical care to cure and relieve from the effects of the injury only applies if first there is a compensable injury. All right? So And as a matter of fact, even in the Tillotson case, if you read the opinion, there's a nod to Gordon v. City of Ellisville. The Tillotson court acknowledged Gordon and said, we're not disturbing that opinion. We agree with Gordon, but in Gordon there was no compensable case. Here in this case, there was. In Tillotson it was compensable, so they had to pay for the entire knee. Armstrong, it was not a compensable case, so Tillotson did not apply. So, that's the primary defense, of course, to the extent it's possible, when the attorney, claimant's attorney, is saying we're going to get a whole lot of medical care here. Well, wait a second. Let's step back and let's make sure that you even have a compensable case in the first place. Obviously, drop a cinder block on your foot and break the bones. Well, this doesn't apply because there's no disputing that there was a compensable injury, and so we have to go to other defenses and trying to mitigate those potential damages. So, while Tillotson is a bad deal as far as medical costs, just keep in mind that it has to be a compensable case. This is where I think one of the valuable tools that you all have at your disposal are these pre-employment physicals. I think it's a good idea if you already have them. If you don't perform those, I don't think it's a bad idea because to the extent you can identify that an employee has some pre-existing degenerative condition, that is only going to help you in the long run. While we may look at an MRI after the injury, and I think the doctors genuinely can look at the films and the diagnostic studies and say to a reasonable degree of medical certainty that what I see there is not an acute injury, it's degenerative. Well, that doesn't mean there's not another doctor that's going to say, no, that's degenerative. And then you've given the judge an opportunity to make a decision. To the extent you can take it out of the judge's ability to make decisions and lock it down, that's when I think the pre-employment physicals are very helpful because if they haven't started working yet and the MRI already shows something, or if they've got complaints and they've talked to the examining doctor, says yes, I take ibuprofen 3 times a day and I go to the chiropractor 3 times a week. That's a good thing to have because then, all right, clearly something pre-existed, and now when your doctor says, well, I see a degenerative condition here, you've got some hard evidence to back that up. So I am a firm believer, and I will tell you when I was looking at these cases, I gave a lot of credence to such things. I hated guessing. I hated flipping a coin. I hated splitting down the middle. I always wanted to try and find something, whether it was subtle or not, to sway me one way or the other. And this is the kind of thing that'll do just that, tip those scales sometimes in your favor. Questions on medical care? Okay. Yes, ma'am. Sorry.
What's the fine line between what is a first aid injury versus what we turn in for workers' comp?
I believe there is in the statute it codifies that you can provide $1,000 of medical, and that doesn't count. If it's first aid, what I say earlier in the inside of the statute that the accident has to be the prevailing factor in causing both the injury and the disability. All right, a paper cut, I would submit to you, is not going to cause any disability. Okay, maybe disfigurement if it's a really bad one, but probably not, of course. So it's going to be a non. There is no injury as that term is defined. So that's probably your, what I would point to is when is it just a first aid case if there's no disability.
But if there's, give an example. We had a lady who does cleaning, and she had her gloves on. She put her hand into the trash, and she was stuck by a needle.
Okay.
And it ended up just being a diabetic lancet. And of course, we took her and she got blood from it. We're paying for it as first aid because she's back to work. I think, and obviously she has needle protocol, she has to go to the doctor. Kind of thing. But it was under $1,000, and we didn't turn in any paperwork. I guess we ended up turning in paperwork, but
that's what I was going to tell you is you want to.
But
You always should, and here's why I say that. Even just because you report an injury doesn't create a comp claim where there isn't already, where the facts don't support it. Okay. An example: I represent an auto dealership. A guy who comes in as an independent contractor. The question was, should I turn in paperwork if it's an injury only or first aid? So this independent contractor, clearly an independent contractor, not an employee, which is, of course, if you're not an employee, you're not covered under the comp. Slips in some wet concrete, they're doing some construction. All right. There's an attorney that represents him, and he lets everybody in the world know I represent him. So that triggers a referral to me. And of course, the adjuster, this is preposterous. It's independent contractor, not comp. I agree with her. So I send a letter to the attorney saying, look, this is an independent contractor. He agrees, says, I'm not planning on doing anything. Fine. Send me a letter just saying that. What's going to happen with the comp, the division, they get a denial. Okay, the employer or the insurance company sends a denial and files with the comp system. If the employee doesn't do anything with that, 60 to 90 days after that denial is filed, it goes away. The case is closed. So you're not paying out any benefits, and in this case, just because, and they filed a report of injury, because that was really the smart thing to do, because if you don't file the report of injury, there's a 3-year statute of limitations. File the report of injury timely, you're fine. You want 2 years to be able to put this behind you, and if all of a sudden hepatitis or HIV shows up more than 2 years, you're okay. Okay, if benefits, it's 2 years from the last time benefits were provided. So I would always encourage error on the side of report of injury, even if you think it's a paper cut, maybe not. Okay, but really anything beyond that, at least notify the insurance company and let them decide. Because if it's a question, they're probably going to call me or whoever attorney they use and say, hey, Matt, what do you think? And I'll probably tell them it's not a bad idea to file a report of injury, and then we'll just make it go away. But you're better off doing that. The penalty for not is not good. Any other question? Plus, they can go out and get their own medical, and then you're stuck with that. And if they get a doctor that says some crazy things, you're kind of stuck with it. So, yes, ma'am.
This may be a little early for this question, but we had an employee that had a back injury, and after all of the medical care, it was determined it was a pre-existing condition.
Mm-hmm.
It was degenerative arthritis. So according to all your court cases, we probably shouldn't have settled, but our carrier did settle with him. And now he's no longer employed with us, but now he's come back with a lawsuit for emotional distress because of that accident. Where does that fall?
You're fine. You're fine. There's nothing you can do to prevent somebody from filing a lawsuit. All you can do is defend it. All right. And you're talking about it's a suit against the employer?
Yes.
Okay. Even with there has been some question as of late as to whether or not the exclusive remedy provision, and that's what we talk about, the fact that the question was, an employee suffers a back injury, has settled the case, and now the employee has come back and filed a claim or a lawsuit against the employer based on some emotional distress. Is that a fair recitation of the question? Okay. There has been, since 2005 and more recently, there has been some question as to whether or not the exclusive remedy provisions found in 287-120 apply to occupational disease cases. All right, you're starting to see these asbestos cases pop up in circuit courts and things like that. Was this an accident?
He was riding on a lawnmower and hit
Okay, that's an accident. There is no doubt in anybody's mind that the exclusive remedy does apply to accidents. So while you may have to, your PI, your general liability carrier is going to have to, if they filed a lawsuit, is going to have to engage an attorney, and they're going to file a motion for summary judgment, and that motion for summary judgment is going to allege that there's no disputing that there was a comp claim, it was settled, this was covered under comp, that's exclusive remedy, court doesn't have jurisdiction. And I presume, based on the facts you've told me, that the court would certainly agree with your defense attorney. People ask me all the time, can I sue for that? And the answer is always yes, you can always sue. The question is really what most people want to know is, can they win? And I would say that this person probably cannot win, at least on the facts you're telling me. Okay. Yeah, here we go.
Going back
Yes.
So they initially had an accident,
Mhm.
or comp authorized the treatment and the surgery,
Yep.
and there was no tear.
Yep.
So then is the employer then required to pay for that treatment, for that surgery, but not for future medical at that point in time?
There's some real question as to whether or not the employer is responsible for any of it, even the care that has already been provided. Now, good luck getting it back, okay? But if there's not a compensable injury, the employer is not responsible for benefits, which would include the care that had been received up to that point. Now, then you might get into a situation with the the doctor saying, employer and insurance company, you need to pay me because this was authorized care, inappropriately authorized, but authorized nonetheless. And since you aren't paying me, I'm going to file what's called a med fee dispute, and I'm going to get the division to order you to pay me. Now, arguably, you could then turn to the employee and say, hey, you owe me this money for all this treatment we rendered or that we paid for. But as a practical matter, unless you have a different set of employees than I'm accustomed to, you're probably not going to get it back. And the question was, in Gordon v. City of Ellisville, yeah, I know, yeah. In a Gordon v. City of Ellisville situation, what's the implication of the employer's responsibility to pay for that medical care and getting paid back? I saw another hand start to go up. Yes, ma'am.
Is there any point where if an individual has had an injury, they've been getting medical treatment on their own, and then suddenly 4 months down the road they come back to the employer and say, oh yeah, well my doctor's decided this is work comp. Is there a line where the employer says, no, we're not responsible because you haven't reported it to us?
Yes and no. Okay. The question is when the employee has been receiving medical care for a substantial amount of time, say a few months, on his or her own, and then all of a sudden it is determined that it might be a comp-related issue, at what point does the employer, or what point can the employer say, look, it's too late, you're not going to get comp benefits? There is a notice provision in the statutes, and the notice provision requires that the employee provide written notice within 30 days of the injury to the employer. First of all, in spite of what it says, written notice is never actually required. Verbal notice always suffices. There is a little tail to that says unless the employer can show or the employee can show that there's no prejudice. I would suggest that is prejudice if all this opportunity to direct care that you lost out on because the employee was getting care on his or her own. I would say that's prejudice, but the courts don't agree with me on such things. So if it's an accident, I think yes. I think you've got a great notice defense, okay? And those do come up. They're rare. They're terribly hard to win on. It's always, even in light of the statutory changes and the interpretation changes, they seem to break for the employee. Now, the difference, though, is with occupational disease cases, and truly that's when it comes up more often. The employee is complaining, my hand hurts and numbness at night. I'm going to go to my family practice physician, get this checked out. They start doing steroid injections, and eventually say, oh, wait a second, this is carpal tunnel. And what do you do for a living? Oh, you're a typist? I think this is work-related. Okay? Once that happens, that's the triggering event for an employee to provide notice. 30 days starts on that day. Okay? There's a case called Alcorn v. somebody, probably Saint somebody, that talks about that very situation because it's not an occupational disease and the employee doesn't have a knowledge of that it's an occupational disease until a doctor says you have a condition as a result of your work. Right here, yes.
Okay, so we had someone wait 6 weeks to report an injury.
Mm-hmm.
They told their supervisor, they told their coworker within 5 minutes of it happening.
Okay.
But no one reported it to the office where we report the work comp claims.
Right.
And so therefore 6 weeks later, we're just finding out that they need to be...
You're on the hook.
Yeah,
that's
what I'm...
The question is the employee told the supervisor and co-employee within 5 minutes of the injury happening, but that message was not relayed until 6 weeks after the event. Is that good notice? And the answer is going to be yes. The courts will treat notifying a supervisor as notifying the employer. And my partner actually took a case up to the Court of Appeals on that very issue and there were some screwy things going along with it. But at the end of the day, I'm going to just say that that's going to be treated as notice. Who is the employer, right? Who is the employer, right? The employer is only people, and so you know you can't.
That was my philosophy.
So
My boss argued it though. Her point was, well, they didn't do it within 30 days. And
tell your boss the fancy lawyer man said you were right. Anybody else need their ego stroked? All right. Randall or anybody else, give me the hook whenever you decide you want to do a break. I'm just going to keep motoring on rather than looking at my... Oh, okay. All right. We started at 8:30. Let's go till... Yeah, I've only been an hour, it looks like. So 9:30? All right, I'll keep going. All right. And I'm going to breeze through this anyhow. Permanent disability. This is not rocket science here. Most of you, I think, probably have a pretty good grip on this. The reason I brought it up is I just kind of want to talk about what the judges think of this stuff. So, permanent disability, you've got two kinds. Permanent partial, and that's a proportionate loss of use of a scheduled body part. I presume most of you have seen the meat sheet, right? The body parts, elbows or shoulders are 232, the knees are 160, the body's 400, so on and so forth. If anybody can remember the fingers and thumbs, props, because I can't. The ALJ and commission is given virtually unbridled discretion when it comes to assessing PPD. Even if one doctor says 10, the other says 15, the judge can say 20 or 2. Okay, the judge is not bound by those opinions. Does not need to find some place at the endpoints or in the middle. Obviously, almost every time they do find themselves in between, but it is possible. That judge I was telling you about that's very claimant-friendly down in southeast Missouri, he's actually gone outside the bounds and given more PPD than any doctor said, and he was proud of it. So that's a guy that needs to be sworn off of every case. Yeah. But I did like playing golf with him, and my kids babysat his kids, so he's a good guy. He just has weird decisions. So the partial. So this is what I want to talk about just from my perspective when I was ruling on these cases. One of the interesting things that I discovered when I assumed the role as the ALJ is that it turns out that as an ALJ, I cared about things that I really didn't think as a lawyer were that important, if you understand what I'm saying here. My perspective changed, and I've been to law school. I've represented people for a long time. I know what the judge wants. Turns out I was way wrong at times, and I didn't know as much as I thought I did about what the judge wants sometimes. It's the smallest little thing that the judges really find important, and this is really a good example of it. I told you earlier, I really truly didn't like just splitting the difference on PPD. It kind of made me feel like it may appear that I didn't try, or that I wasn't giving it a lot of effort and analysis. So I really wanted to. Now, if the evidence got me there that it was middle, I would certainly do it, but I wouldn't do it just for the sake of splitting the difference. And so, you've got your usual suspects. You've got your same doctors saying it's a 40% of the knee with that meniscus tear. You've got the treating physician saying it's the guy's perfect now that I did that, or at best suffered 5%. So where on that spectrum would I issue a decision? The physical therapy records I found most beneficial in the physical therapists spend more time with the patient. They give a lot more information at times about the patient. They've got some subjective tests, the active, the passive range of motions, the JMAR grips, and so on and so forth. And so those were things that I could read through the doctor's reports very quickly because I knew what they were going to say. And the depositions very quickly. I knew what they were going to say. And the physical therapy notes I actually spent more time with because that was the stuff that I thought was going to get me, all right, doctors are qualified, the employee seems reasonable, splitting the difference, I guess, is a starting point. Now, where am I going to go from there? And it was the PT records. Also, things like Waddell's. And for those of you who don't know, Waddell's are a test that the doctors will sometimes use to see if the employee is embellishing or malingering, puts the patient through a maneuver that's not supposed to cause any pain, and if the employee says, "Oh my gosh, that hurts," then the doctor will say, "Well, it was a positive Waddell's test," and that was the kind of thing that I saw time and time again, and I thought was enlightening. Of course, the total disability, permanent total disability, is just as it sounds. The employee is totally disabled. Keep in mind, though, it just doesn't mean that the employee can't go back to the job that he or she had at the time. Okay, if the employee was a heavy laborer, and now because of some injury they cannot continue to engage in a job that requires heavy labor, but they have a PhD, well, then they're probably not permanently and totally disabled. There's probably something else out there that they can do. So keep that in mind. Permanent total disability doesn't mean that they're not allowed to go, just can't go back to their work. It means any work in the open labor market. However, things that are considered are the employee's education, the employee's appearance, how many teeth they have, surprisingly. I mean, because that's what the voc experts are going to do and say, well, this person just doesn't look like somebody that anybody's going to hire. And so those are things that have nothing to do with their work, but they do go into the equation on whether somebody is permanently and totally disabled. Again, this was something that I'd looked at the physical therapy records a lot, and if there was a functional capacity evaluation, I thought that was helpful. The statute, certainly since 2005, says that objective symptoms trump subjective complaints, and so to the extent anything is truly objective when it comes to medical stuff, I thought this was at least more objective. There was a physical therapist that every single patient that he saw in Southeast Missouri, every record, symptom magnification, so he didn't have a lot of credibility. But generally speaking, I thought the PT records were very helpful in arriving at decisions. So, just kind of keep that in mind when you're sitting there looking at it and you get a copy of the reports from the doctors, and our doctor says 5%, their doctor says 40%. Why in the world did the judge believe their doctor more than our doctor? We got a great doctor. Well, maybe it's those PT records, okay? Or if you think, man, you got a great result, maybe it's those PT records. Other things come into play also, just the general appearance of the employee, whether I get that vibe that they're kind of lying or embellishing. What's your pain, 0 out of 10? Oh, it's an 11. No, it's not, because you're sitting here. I get that a lot, or I used to get that a lot. It was always great with the women because I could say, well, have you had children? Yeah. Did that hurt? Oh, that's the worst pain ever. The worst pain ever. Well, do you hurt now as much as you did then? Absolutely not. That's the worst pain ever. Well, so then you're not a 10, and it was easier with the women to get them back from that 10. The men, I didn't have any similar metaphor, I guess. So all I wanted to really talk about with the disability, there hasn't been any earth-shattering revelations when it comes to disability, either statutorily or case-wise. I just wanted to kind of give you a little bit of insight as to what's going on with these things. I will say, just a real quick aside, and then we'll go into break. Every once in a while you may have investigative footage, PI, take a video of the employee. 99 times out of 100 that's worthless, but every once in a while it hits a home run, and I did have one case where an employee said, oh, my life is over, I can't get out of this chair, it's all I do all day. The wife testified, teary-eyed, crying, oh, he's a good man, but he can't get out of the chair all day. And so, well, that's amazing. The employer offered some video footage that I was going to not view there because it was 5 hours of footage. And the claimant's attorney knew it was coming in, had already seen it, didn't object, and didn't address it. So I thought, well, it must not be that big of a deal. One Saturday morning, popped the DVD in, cup of coffee, kids gathered around me, and we watched some guy's video. It was a hallmark moment, let me tell you. I have never seen a man work so hard in one day in my entire life. This guy, who was supposedly chair-bound, picked up his 4-year-old granddaughters, put her in the back of the pickup, took her out. His lawnmower wasn't working, so he needed to move it. His riding lawnmower, so he pushed it around with the steering wheel and pushed his lawnmower. He decided he wanted to move a wood pile that day, which consisted of 4x4s, about 6 foot lengths. He did that. His wife showed up grocery shopping. He helped bring the groceries in, grabbed the bags. She ran up the 2 or 3 steps up into the storm door there. It was a trailer up on wheels. And she didn't hold the door for him, so he gets up and grabs the door with his foot and pushes the storm door open and gets in, and then finally decided he was going to till his garden that day. So it was the first day of the year, or first time tilling, so he spent a good 25 pulls on this thing, getting it started, and then tilled his garden. And he sat there in court and told me he couldn't do a thing, and he knew I was going to see all the stuff he was going to do. So sometimes PI footage does work. I gave the guy 0, as it turns out, by the way. I didn't believe him. And go ahead.
You say normally there's footage that would show somebody doing work and they claim they can't?
No, normally if the footage shows them doing work, it's very helpful. Oftentimes, that was a home run. This PI investigator must have just been giggling the entire time about he's going to be, he's made it in the big leagues now because he's going to use this as his showpiece for how awesome he is as a PI. Because oftentimes it's just a shaky cam of a house where nobody comes in or out. So it's, in that regard, it's not helpful. Or you do catch them going out to the gas, or going out, and they get out of their car, they shuffle over, put gas in, shuffle back to their car, and go back. Well, what does that tell me? Not much. We all knew that they could ambulate. They just don't like to, and if there's any question about that, of course, that was the day they were on the Percocet, and so they were having a good day, driving, but having a good day. So the pain wasn't that bad, So generally speaking, it's either footage of nothing or it's rather benign footage. Now, if it's something like that, that's going to be great every time, and it certainly was. All right, any questions about PPD? What's that ALJ thinking? Okay. All right, I guess we're going to take a quick break. If anybody has any questions during the break that they didn't want to ask, feel free to, I'll turn the mic off.
I want to point out a couple of things real quick before we take off. I thought it was very interesting that Matt mentioned a couple of things. Pre-employment physicals, which any of you have ever heard me speak, I can't go long without mentioning pre-employment physicals, work comp record checks. There's one piece of legislation, Senate Bill 34 in Jefferson City, that was passed the Senate, may actually end up in law, that says the Division of Work Comp has always been required to provide work comp record checks to you if you get the employee to sign the notarized form and all that good stuff. A lot of employers don't use those for a couple of reasons. You need to have job descriptions they're kind of bulletproof to make sure you comply with the Americans with Disabilities Act. But the other thing is you had to fill out a form, get it notarized, send it to Jeff City, mail time up, mail time back, meant that it might take 6, 7 days, 10 days, whatever, to actually get the record back. And as most of you employers know, a good employee or a good applicant's not going to wait 10 days for an answer from you. They're going to want to go somewhere else. Senate Bill 34 says that the Division of Work Comp has to make those records available to you electronically, which would be a huge, huge benefit to Missouri employers. That has not come out of the House yet, and obviously we don't know whether the governor will sign it or veto it or what will happen in September in the veto session, all that good stuff. Of course, there won't be a veto session if nothing ever comes out of the Senate or the House. There won't be any need for it. But we are hopeful on that in the HR world. So that could happen. I also liked what Matt said about the physical therapists. I've always been a huge proponent of really working with physical therapists that know and understand work comp. They can help you with the pre-employment, the job descriptions that talk about the physical requirements of doing the job, which will then help you comply with the Americans with Disabilities Act and make you legal in checking work comp records and using that in your hiring decisions. So Isaac back here with ARC can obviously help you folks with that. I've met with them, but there's other folks out of Kansas City, and they are very familiar with that process. So if you're interested in that, talk to him. I only want to point out 2 more people before we go to break because I didn't see them around. Lynette Weatherford and Sonny Fuller back here. Lynette and Sonny work with us very, very closely. Sonny's actually in our office a couple of days a week, and I know several of you have worked with them or heard us mention them. They provide human resources services to our clients, and they also provide Sonny is our work comp claims manager, so she actually helps you, works with a carrier. We realize that if you're an employer and you have 3 or 4 claims a year, you're not going to become an expert in work comp. If you're like some of my clients in here that are really large clients and you have 100 claims per year, obviously you're going to be getting used to the process and so forth. so forth. So what we try to do is we try to make sure that we provide you a very qualified, competent person that can act as your liaison to go between you and the claims adjuster at the insurance carrier. And if Sunny's working with this claims adjuster with 100 different clients, she's on the phone and she has a relationship and she knows these folks, whereas you only have 1 or 2 claims a year, you're not going to have that relationship. So we as your insurance agency try to do that. So Sunny, back here in the back row, if any of you have worked with her, talked to her on the phone, but have never actually got to meet her, I encourage you to go back and say hi to her. And also same thing with Lynette on providing human resources. If we could, let's take about a 20-minute break and be back here in about 20 minutes, and we'll finish up and go from there. Thank you much.